663-4814 or visit us online at oltmanpatent.com. That's oltmanpatent.com. Spokesperson, not an attorney. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors. The content of the following program, including all statements from the host and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by a host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material from this program should not be viewed as a substitute for personal consultation with an attorney. Welcome to Talk Legal with Jeff Van Treese, who brings you all the latest news in the legal world. Jeff will be discussing a variety of legal topics with experts in the field. If you would like to ask a question or share a story on the air, please call toll-free 888-565-1470. Once again, that's 888-565-1470. Now, let's talk legal with Jeff Van Treese.
Good evening and welcome to another edition of Talk Legal. I'm your host, Jeff Van Treese. I'm an attorney with the law firm Oltman, Flynn & Kubler, where we practice intellectual property law, including patents, trademarks, and copyrights. I'd like to thank all of our listeners, including those of you tuning in on the AM dial, as well as those watching online. You can view all episodes of this show on our website at oltmanpatent.com. That's oltmanpatent.com. You can just scroll to the bottom of the screen and view all archived episodes. This evening, my guest is Eric Schwartzreich. He's a criminal defense attorney in Fort Lauderdale. Eric has appeared on a number of national television shows, including The O'Reilly Factor, Nancy Grace, Jane Velez Mitchell, talking about criminal trials, including the Zimmerman trial, among others. And this evening, we're going to be discussing the recent developments in the Baltimore police indictments for the death of Freddie Gray, and we're also going to be discussing the ongoing James Holmes trial. That's the Aurora theater shooting from 2012. That death penalty trial is going on right now. So, Eric, thank you so much for joining us this evening.
Good evening, Jeff. Great to be here. Thank you very much for having me on the show this evening.
Thank you for coming. So, last Friday there were the grand jury indicted the officers on most of the charges in the indictment, including depraved heart murder, manslaughter, reckless endangerment, among others. What are your thoughts on this, on the grand jury's decision going forward?
Well, certainly I think that grand jurors, they can be puppets for prosecutors. The standard for a grand jury is probable cause to indict, lesser than the standard for reasonable doubt. And the prosecutor is in control of the grand jury. So if the prosecutor wants to indict a ham sandwich, a prosecutor is going to indict a ham sandwich. In this particular case, she was almost damned if she did, damned if she didn't. You see prosecutors normally taking a lot of heat for not indicting these police officers and these police-involved shootings. In this particular case, she moved pretty quickly, which is a little skeptical. I mean, how quickly she moved. There's a lot of political pressure in the community, though. These riots going on. There's a lot of unhappiness in the community. So I was surprised, actually, how quickly she moved on this indictment. In Broward County or Dade County, you'll see, and even in Palm Beach County, you'll see these police-involved shootings. They always get explored, and they take them through a grand jury, but they will take years. I mean, this happened really, really quickly.
And what are your thoughts on it? Because, we discussed this a couple weeks ago with one of my guests, and we were talking about the possibility of bringing in a special prosecutor and changing venue, that is possibly moving the trial out of Baltimore to somewhere else in Maryland. That hasn't been done as of yet. Do you expect the defense is probably going to make a motion to change venue?
Absolutely going to make a motion to change venue, but the issue that you have is Maryland is not a very large state, so if they do a change of venue, it will be moved to another venue in Maryland, and everyone in Maryland knows about this case, but I do expect that there will be a change of venue. And as far as the conflict goes, I mean, there's a conflict on both sides. She's also received, from the reports I've read, the campaign contributions. State attorneys are elected officials here and in Maryland. So when they campaign, they solicit campaign contributions. And it's been reported that the FOP, which is the Fraternal Order of Police, the police union involved in the case, had also given money, as well as, I believe, someone connected to Freddie Gray's attorney. So there appears to be a conflict, but it's on a conflict on both sides. And the issue is can she put this aside, and can she administer justice? Now, the skepticism here is how quickly this indictment came down. I mean, it came down in a New York minute. She moved at rapid speed in this case, and it's not so clear-cut as to what happened in this matter. I mean, this is not an intentional act. You talk about depraved murder. You talk about, there's a recklessness element to this, and sometimes recklessness is just an accident. Was it gross negligence? And how quickly that she proceeded with this indictment. And remember, the prosecutor controls the grand jury. They ask the questions. So the indictment came down pretty quickly, and I hope that this was not a rush to judgment and a politicized thing, because politics and doing something political does not always make for justice or for good laws.
Because I know you also practice personal injury, there's this concept called res ipsa, which is a Latin word essentially meaning that something doesn't just happen. Right, it just sort of speaks for itself. In this case, even though, like you said, and it's certainly true, we don't know all the facts as far as who did what. But in this case, you have a victim that whose cervical spine was crushed or was severed. His voice box was crushed in the emergency transport van. It's just the type of thing that sort of speaks for itself, that just doesn't happen on its own. That's something that at the very least is going to be the result of the recklessness of either whoever's driving the van or whoever was in the van or whatever preceded putting him in the van. So, on that level, it seems like there is probable cause for a crime with the reckless standard. Like you said, it's not an intentional act, but the fact that there are multiple officers here indicted, we don't know exactly who did what. Would you anticipate that they might end up pointing fingers at each other?
Well, a lot of times you see that when there's multiple people get arrested. There's a saying that sometimes the first pig to the trough gets fed, and what I mean by that, a lot of times, first person that lines up goes to the prosecutor, cuts the deal, stays themselves, and they get fed. And you do see that when there's a lot of officers involved. However, the police officers, unlike other groups, you do tend to see, we've all heard the term the thin blue line, and you will see police officers back each other up and support each other. So I don't know necessarily when you have 6 police officers, if you will see, as you would see if these were 6 civilian witnesses, how quickly they will line up to the trough to try to get.
And, you mentioned the conflict of interest with the prosecutor. The fact that there's conflicts on both sides, she received contributions from the police union, which you just mentioned, and she also received contributions from Freddie Gray's attorney. They don't cancel each other out. I mean, a conflict, if even one conflict is enough often to disqualify an attorney. 2 conflicts, even some say 3, because her husband is a city councilman, an elected official in this district where this prosecution is taking place. What do you think about that? Do you think that she's going to be able to continue prosecuting?
I really think she should have stepped down. I mean, there's multiple conflicts, but does one outweigh the other? I mean, you bring up a fantastic point. A conflict stands on its own weight. The question is, can she be fair and impartial and put it aside? The only concern that I see here is how quickly she moved. Now, keep in mind, she also, from my understanding, comes from I don't know if it's law enforcement family or law enforcement background. So is the conflict there? Is the appearance of impropriety there? Certainly. Is it enough where it's caused her, or it can be proven that it's caused her to, go after this indictment in such a manner that she did? I mean, that's what makes horse races, and that's the million-dollar question. But I certainly think that at the outset, there are appearances of conflict, and it's always better to have a special prosecutor when you have these appearances. So the justice system is not a mockery. You want to make sure things are done right. You want to dot the I's and cross the T's. If these officers deserve to be indicted, then they deserve to be indicted. If a crime was committed, they should be indicted. They should go into our justice system. They're still proven innocent until proven guilty just because they get arrested. doesn't mean that they're guilty, but if there is criminal wrongdoing, even of a negligence or a reckless or a manslaughter type of act, they deserve to be indicted. The problem is when you have these appearances of impropriety and you move this quickly, when things on the wheels start turning this quickly, it just appears that, something might not be right here, and you don't want to be scratching your heads. You want to protect the innocent, and you also want to protect the victim here. So you want to make sure justice is done, and you want to make sure justice is done in the correct fashion. So I think if there's any appearance of impropriety, she should just step out and let a special prosecutor, decide what's going to happen and handle the case.
The other thing, of course, is that if they are convicted, this is going to be an issue on appeal. Conflicts of interest are always issues on appeal, and if the appellate court agreed, that might be the case might be overturned at a later date, and the only way really to protect that.
That goes to the heart of the matter, Jeff, and that's exactly the reason. We don't want to do this twice. It is very expensive. It costs the taxpayer hundreds of thousands of dollars, if not millions of dollars in a case like this. We want to make sure it's done the right way for all involved, for the taxpayers, for the victim, for the alleged defendants, and to do something in a fashion where it's going to get overturned because there was an appearance of impropriety, there was a conflict, and you did not recuse yourself. I mean, you're going back to the well twice, and that's a mistake that we should never have made in the first place, or we don't need to be in that situation.
Yeah, and this brings up the question that has been brought up in the news a lot lately, which is whether officers should be wearing body cameras, and perhaps also cameras should be present in these emergency transport vans to determine what's going on. With the with the death of Walter Scott in Charleston, South Carolina, after being shot in the back, there really wasn't any unrest in the wake of that shooting because the officer was charged very quickly and everyone knew what happened. It was on camera. It's often when the facts are obscured by not having events recorded on camera, that's when people are left to speculate, and that's often when you have a lot of controversy and discord.
Yeah, it's very true. In that case you're talking about, I think it was in South Carolina, on that video. I mean, it was clear from that video. I mean, here was someone that was running and was shot in the back, and the proof is in the pudding. I mean, it was on tape. So, the push for body cameras, police officers in general that I talk to, they're against it. They don't like it. Their unions don't like it. Privacy issues. But really, at the end of the day, we are going to get to body cameras. And I think it protects everyone involved. It protects the accused. It protects the police officers. And cameras tend to, emphasis on the word tend to keep everyone honest, as long as it's not a situation where the camera can be controlled by a belt clip or turned on or off. But, then everything, everyone values their privacy, and police officers will say they're police officers 24/7. When they're on duty, they're off duty. Everything gets captured on tape, but that's what we're coming to. And as a criminal defense attorney, I can't tell you, I think it would be better in certain cases for me as a defense attorney when I try cases when there's a camera, and there'll be certain cases when the imagination's not there, the reasonable doubt is no longer there because they can actually see it in black and white. But if you really want an honest, and it's like, you go to the instant replay in baseball, to use a crude analogy. Baseball historians, they don't really like going to the instant replay, but actually seeing it and seeing that it's there, because we want to get this right. I mean, justice should be about truth. Nothing less, nothing more. And,
it'll be very interesting to see how this case progresses. Like you said, when all the facts come out, it'll be really, hopefully the truth will come out at trial one way or the other. I'd like to turn our attention to the Aurora shooting trial, which is ongoing right now. In that case, it's an insanity plea, and he's charged with the murder of 12 theater patrons back in 2012 after arming himself with body armor when he came to the Batman premiere and shot up the theater. The defense of insanity here is coming down to, it appears based on the opening statements, it's going to come down to the planning and whether that would disqualify him from an insanity defense. What are your thoughts on the progression of this trial?
Well, insanity defenses are always tough. I don't think for decades there's been a public or a high-profile mass murder case where the insanity defense has worked. But if there ever is a case, I mean, it's clear to me that this guy has sanity issues. He has a history of schizophrenia. I think he has it on both sides of his family. You can even see it. I mean, we've all seen the now famous mugshot with his eyes bugged out and the orange hair and his mannerisms in the courtroom. But it's just such a difficult, tough sell. What they have going in their favor is Colorado, the state of Colorado. It actually helps the sanity defense because Colorado happens to be one of the few states where the prosecution actually has to prove that the defendant was sane instead of the defense having to prove insane. Now, how much do burdens matter? That's going to be the issue. But in that sense, the burden of proof is on the prosecution, so they start off better that way. But, jurors classically do not like sanity defenses. And in this case, it's so horrific what happened. And I've had the opportunity to view the prosecution and the defense's opening statements. And, I was a little bit shocked. I mean, I know prosecutors do this, but how much the prosecutor, he started off saying that behind this door, was horror, and he had an image on the screen of the movie theater, and then he referred to the theater as a box and what happened in there, and you started talking about the victims. Now, certainly the prosecutors that represent states or Commonwealth have a right to present relevant evidence that tends to prove or disprove material facts, but the succinct issue in this particular case was sanity, and what the prosecutor was really doing, and effectively so, in his opening statement was tugging at the heartstrings of the jurors and, of the horror that happened in there. And the defense came back and did a good job of bringing in what the issue is, talking about the court-appointed doctors. But at the end of the day, I mean, sanity really is a tough pill, a very hard pill for jurors to swallow, because in the back of their minds, they're always concerned, they're wondering, they're concerned, if we find this guy not guilty of reason by insanity, is he going to get out one day? Is he going to be released? Recently, we have John Hinckley, which has been in the news, who was accused of attempting to assassinate President Ronald Reagan back in the 80s. Now, I mean, was it 30? I'm getting old now. 30 plus years later, and he's finally being released or assimilated back into society, and jurors are concerned about that. If they let this guy go,
Eric, let me just ask you this real quick. Can you, if you were the defense attorney for James Holmes, would you try to bring this out in voir dire with the jurors? If you were to ask them, can you disregard any concern that they may have with respect to the defendant one day being released? Because if they say yes, that's gonna be a factor that I consider in my verdict, then arguably they should be disqualified.
Well, in voir dire, the process of jury selection, the French term, which means to speak the truth. Yes, I would ask that, and that's where lawyers will tell you they either win cases in depositions in states where you're allowed to take depositions, because in federal court you can't, or in jury selection. And you really have to do an efficient, good job of talking to the jurors and asking the right questions. The problem is that not all lawyers ask right questions or know how to speak to jurors. They tend to, I'm not saying that the defense attorneys did this in this case, but they tend to lecture jurors. And jurors will not always be honest. They will not always be forthcoming because they think that they want you to give them a certain answer. So you really have to talk to the jurors, make them trust you, and explain to them that this is really important, because if they hold that belief that you're talking about, that they're concerned in the back of their mind that this guy James Holmes will be released one day, and they're not supposed to consider that, and that person should be excused, removed for cause from that jury. So you hope to flesh that out, and you hope to flesh out a lot of how their feelings, what they feel about mental health, family members with mental health. In fact, there are jurors on this James Holmes trial that have mental health, that have family members with mental health issues, according to the reports that I've read. So you want to flesh out, and you want to know who your jurors are, because two separate juries with the same sets of facts of case, I've experienced this personally, but I've had co-defendants one jury could find someone guilty, and the same jury in the some set of facts could find the co-defendant not guilty, because people have different perceptions. So if you're going to win a sanity defense, and like all trials, but in particular in a sanity defense, you've got to get the right jury, the jury that is open-minded and that will honestly talk to you and put those biases and motives aside and really determine, was this guy able to appreciate the consequences of his actions at the time that he committed this act?
And of course, another issue with this jury is that there are two jurors that have that have very serious ties to the Columbine massacre from 1999. I believe that one is actually a relative of a survivor of that tragedy, and that was a huge mass shooting when that occurred. That resulted in the death of I want to say between 10 and 15 victims, somewhat similar to this one. It would appear that those jurors should have been disqualified, but they ended up being placed on the jury.
Now, I'd agree with that. Now, the litmus test for jurors' qualifications is whether or not they could be fair and impartial. I don't know if the dog is going to hunt or the duck is going to fly, for lack of better analogies or terms. In other words, if you can just remove someone for that. But it would, if they answered, then I could put it aside. But I would certainly expect, and I would imagine, that it is an appellate issue that has been preserved, and certainly you would not, as a defense attorney, just at first blush, there's no way, no how, I would want jurors with those ties on the jury panel. Now, I also read in a report, I don't know if this is true, that one of the jurors also had connections to, I forget the names of the defendants. I remember they were in the group, they called themselves the Trenchcoat Mafia, but they also had, that they knew the shooters as well. I mean, I'm not so sure if I'm the prosecution or the defense, if I want to gamble and put those jurors on. And in an abundance of caution, those are jurors that I would attempt to strike. But, as a trial lawyer, especially in a case like this, and you'll see that these lawyers are objecting and going sidebar like a lot, you want appellate issues. And if you don't ask, and if you don't preserve it, you don't get it. And you want the judge a lot of times, especially in a case like this where they do have an uphill battle, you want the judge to, make rulings that could be erroneous, where you could get a bite at the apple and get a free trial.
Yeah, because like you said, you're discussing the issue of preservation. If you don't make the argument to the judge, then you waive it forever on appeal. And that's something that in many instances you might have defense attorneys ask for a mistrial, even if in fact they don't want one, knowing if they think the judge may or may not grant it. Even if they think the judge will probably not grant the mistrial, they'll still ask for it just because that is the only way that they can then ask for relief on appeal. And like you said, you might actually want them to the judge to make erroneous rulings. If he is convicted, there's going to be a lot of appellate issues, and this would probably take a long time. The sentence may never be carried out. And I think that's interesting against the backdrop that the defense actually was willing to accept a plea agreement for a life imprisonment without parole, and it was rejected by the prosecution insisting on the death penalty, which mandates a trial. And you can correct me if I'm wrong, but I don't believe that the defendant can agree to a death sentence. So if the prosecution insists on death, that requires a trial. And in a case like this, where there appears to be quite a few mitigating circumstances, it appears that decision by the prosecution is somewhat questionable.
It's questionable, and I see it all the time. I personally experienced it. The prosecution is like, no, we're not taking death off the table, and they say death is different in death cases, and they want their pound of flesh, in this case, the prosecution, and it's been, that's been also spoken about in opening statements briefly by the defense attorney, and they're looking to get their pound of flesh. They want, this is a high-profile case. There were a lot of people whose lives were lost. It's a heinous crime in that movie theater, and I'm sure, it would be a win. If the defense could get life in prison right now, there wouldn't be a need for a trial. In fact, if they go not guilty by reason of, sanity, which they're doing, and they prevail on that, he's still going to be in the facility probably for the rest of his natural life. He'll probably never walk among us again. But prosecutors weren't having that, and they're going to spend the money and the time. And, unfortunately, I see that a lot. And when they'll stick their heels into the sand, and there's no getting out of that and no turning back.
In just a couple minutes we have left, I was wondering, if you were defending James Holmes, how would you present the defense? How would you try to overcome the fact that there was a lot of planning involved, and the prosecution is arguing that only a sane person could engage in this much planning?
Well, that's the issue, and that's the problem for the defense. I believe in embracing evidence, and you can't run from evidence. A lot of times the defense attorney will have DNA, will have confessions. We have it all. You can't run from it. In fact, doing this for 18-plus years, you learn that if you're disingenuous with the jury, you lose credibility. Credibility is everything you have. So you've got to paint it in the color of which it is, and that is that this is an individual that's diagnosed with schizophrenia. This is an individual that tried to kill himself when he was 11 years old. This is an individual who kept a notebook, and if you read the rantings of his notebook, prosecution might call it planning, but he doesn't really think he's planning with like the premeditation to commit murder. He's almost like he's in a warped sense of reality. So you're going to have to embrace the planning and show that the planning is not the planning what it means for premeditation under the law, or what it means to you or me. It's planning of a schizophrenic person that's under the cloud and control and the judgment of someone with schizophrenia. And he's not acting as a sane, sanity is a legal term, but he's not acting as a legally sane person. And you would have to couch the argument of the planning in that terms, and I imagine that that's what we're going to see happen here in this case, because that's what the million-dollar question is. That's what they have to overcome. He bought lots of guns, weapons, gas canisters, online purchases. There's comments in his journal. They're going to have to show that he didn't really know what he was doing. It wasn't planning to kill. He was under the cloud, of what was going on with his schizophrenia. And that's how this is going to have to be presented.
We're going to have to leave it at that. I'd like to thank my guest, Eric Schwartzreich, for appearing. Eric, if you could give out your contact information to our listeners.
Sure, it's Eric Schwartzreich, and that's Schwartzreich and Associates, and it's criminal defense attorney.com, FloridaCriminalDefenseAttorney.com, and I'm on Twitter at A Reason for Doubt, and my number is 954-873-8228.
And I should say your office is very conveniently located. You're right next to the Circuit Courthouse in Broward County. Again, I'd like to give a very special thanks to my guest, Eric Schwartzreich. This has been Jeff Van Treese for Talk Legal. Please tune in next week where I'll be interviewing Bill Crispin. He's an agricultural attorney, and we'll be discussing some recent cases with Monsanto and GMO labeling. I'd like to thank all of our listeners. This is Jeff Van Treese for Talk Legal. Thank you so much, and have a great evening.
Thank you for listening to Talk Legal with Jeff Van Treese. Tune in next week for more insightful and exciting information about the law. You can contact Jeff by email at jvt2law@gmail.com or give him a call at 561-789-6866. That's 561-789-6866. The content of the preceding program, including all statements from the